I'm going to take a chance to introduce myself to people who I haven't had a chance to meet yet. So I'm Nicole Cook, and I'm the Agricultural and Environmental Faculty Legal Specialist at the University of Maryland Eastern Shore. And I am delighted to share with you all today that I am no longer a solo practitioner. We actually hired our senior legal research associate, Samantha Capaldo, and she's here, so say hi. I do want to let you know that she has a publication coming out soon on workers' compensation for ag employers in Maryland. So I encourage you to look back to us for information about that. And I also want to share that we actually have our newest Maryland Sea Grant ALEI legal fellow, Carrie McClaughley, who, there she is, over there. So every year we have a fellow who works out of the College Park Sea Grant, Maryland Sea Grant offices, and works with me. I supervise the fellows, and part of the work that they do is a concentration on the aquaculture industry in Maryland. And she is a law school graduate, Maryland Carey Law graduate, and she passed the bar. So, all right. So our next panel is, if you don't, who knows Hans and Dwight? Oh, I was expecting every hand, so yeah. They've been with us a while, so thank you so much for being here again. So we have our panel right now to give us updates on Maryland's food processing residuals utilization permitting law. This is a new regulation implementing Maryland's new food processing residuals utilization permitting law. And so we have with us today Hans Schmidt and Dwight Dutter from the Maryland Department of Ag. Hans is the Assistant Secretary for Resource Conservation, and Dwight is our Nutrient Management Program Administrator. And I'm going to let you guys take it away.
All right. Well, is this on?
Is that on?
Is it on?
Can you hear him?
Can you hear me? Okay, good. So good morning. It's a pleasure to be here this morning. It's quite a contrast to go from value-added agriculture to food processing residuals, because the two do not really mix. They're kind of like oil and water. But as Nicole said, was legislation that was passed this past year that dealt with the utilization of food processing residuals. And this morning we're going to kind of go over that definition of what FPRs are, give us some background of what led to the legislation. We're going to talk a little bit about the law and the regs that were passed, the application process, and the implementation and the enforcement that the department is through the Nutrient Management Program. So food processing residuals, here's a definition on your screen, means an organic material generated by processing agricultural commodities for human or animal consumption. The term includes food residuals, food co-products, food processing waste, food processing sludges, or any other incidental material whose characteristics are derived from processing agricultural products for human consumption or animal consumption. So just more in short term is, if many of you like to eat, many of you will take chicken, for instance, who like to eat chicken, many of you who like to watch the Super Bowl and probably have chicken wings, that meat has to be processed. And when you go through this processing, there's going to be a waste stream or wastewater, waste sludge that comes from that processing, and then that waste stream needs to be used in some form of matter. And in many cases, these products are spread onto farm fields. There's a nutrient component to these fields, to these products. There's an analysis that is done. It's registered through the state chemist. But those nutrient components are important to the next crops that are being grown. I said it's kind of like a circular system. Farmers grow the grain is fed to the chickens are processed for you and me to eat, the waste stream goes back on the landscape to fertilize the next crop. The same could be said for milk waste or seafood. We live in Maryland. Seafood is a big food consumption here in Maryland. Everybody likes it, but there's a waste that needs to be used, and so that waste is turned around and put onto the landscape. Again, it has a nutrient component to it. It's approved by the state chemist, and so those products can be used for in an environmentally safe way through our nutrient management plans, and those nutrient management plans have what is the guidelines or the limits on how much nutrients can be applied to your farm fields. And in many of these cases, these products have a very low analysis, very low nutrient analysis. And so you can apply, according to the nutrient management plan, you can apply pretty large volumes of these products. The contrast to that is that there are some issues that come along with that, and primarily odors and truck traffic when you're hauling a lot of these products. And again, most of these products are the DAF, or the dissolved air flotation, which is a process that a lot of these processors are using. As I said, milk waste, seafood waste, and again, most of these products are really in a liquid form, some in a more solid or semi-solid form, but mostly liquid form. So over the years, and I've been with the department for about almost 9 years, Dwight's been with the department 20 some odd years, this has been an ongoing issue amongst the communities of where these products are being land applied, primarily complaints in truck traffic. And when we receive those types of complaints, we respond by going out to the farms, meeting with the farmers or those who are applying these materials, make sure that everything's in order with their nutrient management plan, go and meet with the complainants to make sure that we have addressed this issue. And we have found in most cases, farmers are not out of compliance with their nutrient management plans, that they are in compliance with the letter of the law of the nutrient management program. The problems come into odor and truck traffic. Truck traffic, we have no authority over, and even with the odor issues, we don't, to some extent. Now, in 2023, I believe it was, or 22, the Department of Agriculture, working with the Nutrient Advisory Committee, developed regulations that required farmers to incorporate these products into this, either incorporate or inject these products in, incorporating to try to smother some of these odors. It's not 100%, but it does help to a great extent. As I said earlier, that these products have a relatively low analysis, and so you can go across these fields multiple trips, and the longer you're there before you plant your crop, the longer the odor is going to permeate and stay in that area until the farmer is ready to grow their next crop. And so a lot of these discussions were in a place when we were going through and working with the sponsors of the bills that were passed. So as I said, you know, in January of 23, we did put in some rules for making sure that there was a requirement for incorporation or injecting of these products. Now, there was one caveat, though. If you had hay or pasture ground, you didn't have to incorporate or inject, because if you did that, you would destroy your hay crop. And those farmers who were using these products but also had hay ground had some problems with that. So we did make that allowance, that exception, where farmers who were applying these products to those crops did not have to incorporate. So in 2024, in some of these areas, in some of these communities where we were getting a lot of calls from about how the odors and the truck traffic were impacting their quality of life. And it got to a point where prior to legislation, or the legislature session, that these citizens within these communities had contacted their legislators, both at the state level and also at the county level, to make sure that the legislators understood of the issues that they were dealing with. And at the time, in the last year or so, there have been 2 counties that have either put a temporary or permanent ban on site on storage for FPRs. At least one county has placed restrictions on any new construction of storage facilities. And then, Dwight and I missed the very beginning on the right to farm discussion, but you heard in Talbot County about the issue with right to farm. So it was, how do we deal with these things, these issues moving forward? So House Bill 991 and Senate Bill 1074 were passed this year. Originally that bill, the original legislation language was giving MDE the authority to manage these products. We went through the discussions with both MDE and the sponsors, and then that responsibility was turned over to MDA. Reason being is that we already had some of the resources in place. We had the inspectors out in the field. MDA was responding to a lot of complaints. I know MDE had received complaints, but we were tracking these products through the annual implementation report that farmers are required to fill out once a year. Again, as I said, we were out inspecting farms. We were responding to those complaints. So the legislation passed, went into effect July 1st of this year. It gave the department the authority to establish a food processing utilization permit program. And these were products that are taken to farms. These are not products that are taken to a commercial anaerobic digester or to a commercial compost facility. This is going to products that are going to a farm. And so those requirements within that legislation was that any user of FPRs had to obtain a permit, that this program had to be self-funded, so the department had to set up fees and permit fees and tonnage fees to make sure that we could be self-funded. It gave us the authority as a department that we could go onto the farms. Prior to that, and through our other regulatory roles, we have to reach out to the farmers first before we enter. We just can't enter farms nilly-willy here. So we have now the right that as we receive these complaints or through the permit process, because a farmer may be or an applicator has received a permit, now we can enter those farms during application or to inspect their records and so forth. Also through that legislation, it gives the department the authority to develop a commercial hauler certification program. So I mentioned what FPRs are. What FPRs are not are digester digestate, animal or poultry manures, biosolids, compost, mushroom soil, or water plant residuals, unless FPRs are put into the mix with any one of these products. If they are put into a mixture with any of these products, now it falls under the legislation and under the permit. It doesn't matter whether there's no percentage that is set. It's any amount that's applied to these products is required to have, the users are required to have a permit. Also, another exception is if products are generated on the farm. Say, for instance, a dairy operation has a creamery and they have a waste stream. Are they required to get a permit so they can land apply it? No. But what they do have to require is in still applying those products on the landscape, they still require to incorporate or inject, and they still need to follow their nutrient management plan. So when the legislature finished, what was it, July, middle of April and so forth, these regulations went into effect July 1, which gave us almost an impossible task to have regulations ready to rock and roll by July 1. We developed some regulations, we presented to the Nutrient Advisory Committee. They came back with some changes and some recommendations that we needed to address. We took those back. We revised the regs, we sent them over to AELR, and we sent them as emergency regs so that we can start this process as quickly as possible. The AELR committee approved those regulations, and the effective date for the new regs was October 16th of this past year. We understood and understand that there needs to be a transition period. The industry is not going to stop processing milk or stop processing meat or any of those things. So they're still generating these products, so we need to go through a transition period. So we set up some guidelines to allow operations to take DAF or take these FPRs to be able to still land apply it. There was one caveat that was in the regulations that said, you have to be in compliance with both the ag and the environmental article. That was one thing that we could hang our hat on and said, if you are not in compliance, you're not getting a permit, and oh, by the way, you cannot take these products, until you come into compliance. And that was immediate. We set all these guidelines up so that farmers can get and the industry can get themselves set up prior to January 1, so that come January 1, we can start issuing permits and giving the industry, time to, get themselves prepared. So applicants, we must have a permit to use these products. They must maintain these records of the products that they're using. There's a tonnage fee of $4 per wet ton, and that tonnage fee is set on the amount of material that's transported. There is allowance, as I said, for on-site inspections during spreading time. The storage structures, and we've gone through some issues in some of the counties where storage is an issue. And whether you know it or not, we've had some guidelines in Maryland for some time now where farmers cannot apply nutrients, whether it has nitrogen or phosphorus in those products, between December 16th and March 1st. You cannot apply these materials. So there is a need for storage. So in some cases, farmers were either using existing lagoons that they had for their animal operations, that they may not have animals anymore, or they had built separate storage just for these products. The good thing about the storage is it allows these operations that, they can collect this material, and then once spring hits, once March 1st, they can get to their fields in a rather quick method, get in and out of those fields as quickly as possible. What we were where storage is not allowed, or particularly during the growing season, or storage that doesn't exist, farmers are dependent upon the volume of material that comes to their farms on a daily basis. So they may get 5 or 6 trucks a day. They may have a 100-acre field. It could take weeks before he gets that field with all the material that he's allowed to through his nutrient management plan, which became problematic for the communities because the odors continue to lie around for that period of time, and the truck traffic and so forth. Storage is a good thing. Storage is good for the method of getting those products on those fields as quickly as possible. And let me also say this, that as I said, the circular system, we're here to make sure that our farmers can stay in business. You talked about value added and bringing more profit back to the farmer so that they can stay in business. We like the aesthetics of agriculture. We like the aesthetics of farms. But in many cases, the profit margins are very, very tight. That is why it's so important that we have a poultry industry that brings such a strong economic base to the local communities. Many of these products, and I talk about poultry, is on the Eastern Shore, where you have one of the largest poultry industries in the country, is that the processors, we do have some processors in Maryland, there are processors in Delaware, there's processors in Virginia. But when these products come in, the question comes up, well, why are we accepting other states' products? Well, understand that a lot of those chickens that those processors are processing are Maryland grown. We're in this region where we want to make sure that we keep the industry going, that we include the economic viability for both those farmers and the communities that we live in, but we also want to make sure that we're doing it in a safe manner, that we can find some sort of balance with everything. These products need to be registered through the state chemist. Any product that's coming onto a farm needs to be registered through the state chemist. And that's not just these types of products. I mean, if it's lime, it has to be registered. Manures are not the case, but whether it's a soil amendment, compost, or any of these types of products, you must be registered through the state chemist. And that's not a new law. That's been in the case for a number of years. Again, I talked about compliance. When we set up this transition period, we wanted to make sure that there was time for the department to review the applications, the requirements in those applications. So we put in 45 days of application. The legislation also allowed for increased penalties where, where we have some violators that are problematic, and really a lot of these cases and the legislation really came about of just a handful of bad actors. There's a lot of farmers out there doing the right thing. They're using they used the product in a way that was both benefit to his farm, but also a benefit that did not impact or minimize the impact to the local communities. But it just took a handful of bad actors that really led to the legislation here. And then finally, we have and we always will work with our sister agency, MDE. We all go out on farms, particularly if there's complaints, to make sure that we're addressing those complaints and making sure that we're meeting all the objectives of the legislation. So I'm going to turn it over to Dwight, and he's going to talk a little bit about the application process.
Sure, we can finish up here. As we said earlier, since we didn't get started into this until October 16th, we realized there was going to be a pretty tight period of time. We were right in the middle of the fall season, so we couldn't really change our regulations. It wasn't fair to go to farmers and say, what you did this morning's okay, this afternoon's not okay. So that's why we chose January 1st as our cutover time. We are going to be looking at 3 different applications. We're going to have what we wanted to do is we wanted to have the transport and storage applications ready to go by January 1st. We figured the land applications weren't nearly as important since they can't land a plant until March 1st anyhow. So we said we want to have applications in by November 15th for storage and transport, by January 15th for land application. That would give us 45 days to review those applications. We are going to be very cooperative. We've had some discussions already with some of the applicants. We will cooperate with them. If there are incomplete applications, we're not just going to sit on them or send them back. We are just going to tell them what they need and make sure they can get it so we can keep it moving. It's our intent is to really work with everybody. As you can see here, I'm not going to read everything that's on here. The fees for the permits are not the real big issue. The real big issue, of course, is going to be the tonnage fee. That's what's going to really add up for those folks to pay us. There's also the bond security requirement. You'll see what's on here. We have a worksheet where it's spelled out. It's not, for example, right here for the transport is $10,000 for the first permit and $4,000 for each additional one. The applications are not easy to fill out. They're not simple. We did pet them a lot after the biosolids applications. As you look at them, I think a lot of the farmers themselves would not want to fill them out. They'll need to be filled out by a company that's familiar with how to fill them out. The storage application, I'm going to say, is going to be the most difficult of all, as Hans mentioned. The big thing here is they have to meet the standard for the NRCS 313 standard. We did incorporate that into Supplement 10 of the Nutrient Management Manual along with the regulations. That's going to give that's going to really probably will limit some of the storages that we have seen in the past, unless they want to go out and modify those storages, unless they want to get an engineer to come in and actually approve those storage structures. The ones that are going to be the easiest ones to actually permit will be the ones that have built, I guess I'd say more recently, by the NRCS standards, where all the drawings are available at an SCD office where they can just go pull them out and use them on the application. If they have to have an engineer to go in and actually certify these structures, that may not even be possible in some cases. A lot of engineers probably won't want to do that. They weren't there during the construction. Again, we show them what the permit fee is. Just to mention one thing about the scope of this, we're probably looking at less than 1% of the acres in Maryland are actually receiving any of the food processing residuals. Probably 60-some operators. Some of them have multiple farms, but it's some ways for us it's a big problem, but it's not really a lot of use. The application for the land, again, for land application, they're not going to have to have this until March 1st. We're kind of looking at the fact that maybe they won't have all of these applications ready to go all at once. I think as long as these companies, we want to make sure they have some things permitted so they can continue to operate. As Holland said, we don't want to shut anybody down. We want to make sure, but they may not have everything. For example, on land application, maybe all farms won't be ready to go by March 1st, but hopefully they will. Hopefully we can, if they get them into us by January, we'll have time to look them over. For example, if you look at the bottom where it talks about wells within 1/2 mile. We were told that that's kind of hard to locate those. And they went to the health department in one of the counties. They told them to go to the Department of Environment, and I believe the Department of Environment told them they needed about 30 days. So what we told them was, when you can go ahead and give us the application a while, and just note on the application that that's pending, and then when you have it, let us know, but we're not going to hold up the review of the application. The same thing's going to be true with the bond, but we'll get to that in a minute. Here on the bond, what we're saying on the bond is we're not going to require the bond to actually come into us by November 15th, but we do have to have the bond prior to issuing the permit. There was some question about that. We're saying, don't wait till the last week of December. Some of the banks or insurance companies may not be working that last week of December, and that might hold you up that you couldn't have your permit. We're going to keep moving with, if they won't have to give us the bond, we'll go ahead and continue to review all the paperwork, but we're not going to issue the permit until we actually have the bond. And also the question has come up about on the permits. You see it here at the bottom, they max out at $200,000. So if they look at the bond worksheet, it just depends. If people do all three, if they do transport, storage, and land application, especially a larger company that's going to be doing all the applications, they would have no problem reaching that $200,000 threshold pretty quickly. But here again, some people may choose to only do land application just on their farm, and if they do, the bond requirement would be much smaller. One thing that we did change, now we've made a couple of changes. Everything now liquid on the food processing residuals will have to be injected. In the past, as Hans mentioned, we had allowed incorporation. We will allow incorporation if it's a solid or a semi-solid. They can't be injected, but if it's a liquid, it must be directly injected. Lots of benefits to direct injection. And that also means in hay fields. We actually ran into a situation where we've had an awful lot of complaints about a milk waste being applied on the surface on these farms, on hay fields. So unfortunately, we had to go back and include injection of everything. And one big thing is we do say it has to be 95% coverage. It means we're talking about has to have like a heavy disc or something to incorporate it. Specifically, we mentioned that vertical tillage may not be used. Vertical tillage is not meant to really tear the ground up and turn something under. Vertical tillage is meant to do minimum tillage, and we're not going to allow minimum tillage. Another change for the FPRs only, and that is that the cover crop will need to be planted by October 15th. Now, this is another thing that we did not require this year for a couple of reasons, not only because we were already into the season, but because with the with the dry weather and everything, we knew that was going to happen this year, where the cover crop, we talk about an established cover crop. Well, they weren't able, a lot of them were not able to get an established cover crop this year when you go for over a month with no rain. But after November 1st, going forward next year, after November 1st, all of these FPRs will have to be injected into some type of an established cover crop. And it has to be planted no later than October 15th. I guess I made a bit of a commitment at one time, and we're going to stick to it, and that is that we will be on site making inspections during these land applications. A lot of the counties had a lot of concerns about that. They wanted to make sure that everything was done properly. We're supposed to get 2 inspectors eventually and an attorney. We will not have any revenue. If you can do a little bit of math on this, you'll notice we won't be collecting any revenue until at least the end of July of next year, 2025. So we don't have any money actually to pay anybody right now, so we're going to do everything with our existing staff. So that's going to that will stress our existing staff, and we aim for 20% inspections on farms, and that'll mean fewer farms with inspections, but I think it is important. The good news is it won't be that many sites at one time being spread. If I would said that about dairy farms, for example, there could be 100 of them spread in the same day or more. In this case, I'm thinking maybe, at the most, maybe 5 to 10 farms probably would be spreading at any one time. So I think we're able to do it. And again, as Hans mentioned, we will have right of entry. We're not going to abuse that. We're not going to go in the middle of the night. Both of us have probably gone by farms before in the middle of the night just because people have asked us to, but we're not going to do that. We're going to be respectful. But the big thing here at the bottom is we are seeing farms that are making multiple trips across a field, and that doesn't mean it was necessarily an over-application. As Hans said, depending on the material, some are not that high in nutrient content. But it does create a bit of a problem, especially it extends the amount of time that they're spending going across the fields for the neighbors who see them out there, and then all of a sudden they're going over the field 2 or 3 more times. I've seen some fields where I think the field almost looks like it's tilled by injectors just because multiple trips over. So going forward, it will be 1 trip across the field. Again, just mention the fact that the storage structure is going to be probably the hardest thing to actually get permitted. But when our inspectors go out, once they are permitted, we're not engineers. We're not going to make any effort at all to try to evaluate the structural integrity of a structure. What we will do is just simply look at the structure. We'll make sure it's not overflowing. I'm pretty sure it's probably in the NRCS standard. They have to maintain a certain freeboard, so we'll be looking for that, and we will look for things. Some things, depending on the structure, we may even look for things like to make sure that the fence is still intact and things like that. But we're not going to get into anything that has to do with the structural integrity of the storage structure. And again, just mentioning here a little bit about the fact that we're going to have to operate at this point with a limited staff because, as I've mentioned this before, we will not be hiring anybody at the very earliest until the end of 2025. And we don't know right now how it's going to work out. We based all of our estimates, everything we estimated on was based on our AIR numbers. We do have good numbers on that. We feel pretty comfortable with it. But going forward, we don't know how the industry is going to respond. We've heard a lot of different things about technology. May change things. So we have no clue how much tonnage we're actually going to be involved with. Hans, do you want to finish this up?
Sure. So when we went through and we met with the sponsors, we met with the other stakeholders as well. And the point that we tried to make with everyone is that we need to find some middle ground. We know the importance of these industries. We know the importance of agriculture being the largest commercial industry here in this state. Maryland is not the only state that's dealing with these issues. If you Google it, you can look at other states like Georgia, Alabama, Missouri, and other states that are trying to find some solutions on how do we manage these products, but because the products, the odors particularly, are impacting these neighbors. And so working with the stakeholders and the sponsors is coming up with some sort of solution to make sure it's workable for everybody. When we've met with these the communities and so forth, the majority of them said, I really like farmers. I really like what they're doing. I do understand there are odors that come along with it, but these are different types of odors. These odors don't leave. We can't get out and enjoy, outside in our yards and barbecues and those things. So let's work together to find a solution, and I think we did. I think we found some solutions that allow the farmers to continue to use these products. It gives the industries outlets of these products that they can take these products and use them on the landscape. I know the industries are looking at other types of technology on how to manage these types of products, but I think we came up with some solutions to making sure that there is some oversight with these, where these products are being used, but they're also being used in an environmentally friendly manner. Our goal is to encourage beneficial use of FPRs as soil conditioners. And again, we want to make sure that we are, working with everybody that come up with that solution. As I said, a lot of those neighbors said, I really like farmers. I think they do a great job. I appreciate the work that they're doing. But then I ran into a situation where I went to the complaint and their comment to me was, I think they're running that farm as a business. Well, yeah, they are. And so, there is two extremes here. And when you go out and visit with the complainants, you have to educate them on where their food is coming from, the minutia, the very bare bones to, they have to stay in business if they're going to pay their taxes, if they're going to send their kids to college, that they can have the same quality of life or the same benefits that everyone else has that is not on a farm. Again, we believe in the agronomic benefit of FPRs, and we support the land application, we support the new technology. But, the big key thing is that how do we successfully use FPRs now in the future? And it's really coming down to how do we manage the odor control. We don't, up to this point, odor control is not in our authority. But we can work with the land, we can work with the farmers and say, hey, let's be better neighbors if we can. Let's do what we can to minimize the complaints that were coming, because you live in these communities. I don't live in all these communities. Dwight doesn't live in all these communities. But you need to be a better neighbor if you can, and most farmers have been receptive to that. Again, I said there was a handful of bad actors, and unfortunately, that's what led to this. And just as an FYI, when we talk about injecting, this is an injector. We just wanted to kind of show a picture. And Dwight mentioned about, if you go over multiple times, it looks like the farmer's gone and done a little tillage. This is kind of a middle of the road injector where you are going to see what appears to be tillage. There are injectors out there that you can't hardly tell it's been out there. So we just kind of wanted to show if you weren't familiar with what injectors were. So we appreciate being able to come and speak to you today, and if you have any questions or if there's time, I don't know.
Yeah. Unfortunately, do you want to do one question? One question.
I was just curious, do FPRs typically undergo any kind of treatment prior to application, or can they be certified by the state chemist kind of like as is in terms of land application?
So these products are, samples are pulled from where these products are being processed. They're sent to a lab, a third-party lab. They test it. There's the state chemist has requirements on what to be tested for, and if it meets he sees the results and meets his what he's looking for, then it can be registered and be land applied from there.
Well, thank you. Yeah, actually, thank you so much, Hans and Dwight, and you will be with us today, so folks that have questions can find you in the room. So thank you, everybody. Thank you very much.
Getting my timer out so I don't go over time with this. So I'm Paul Geringer. I'm a principal faculty specialist and extension specialist in Ag and Resource Economics, and you get the joy of listening to me give the legal update for the year, and I'm really glad that Peggy and Jesse are here to heckle me because I heckled Jesse in a group text while he was presenting twice. So this will be payback for me. Oh boy. Get my timer started. Yep. So we'll go ahead and get started. Oh yes, I have to remind you, university programs are open to all. And this video may or may not play, and I forgot to tell the gentleman that there was one video with sound. So I will continue on. So on to our introduction. So today we're going to use this as my therapy session to talk about some of the issues that I've looked at over the past year and then some things others have told me to look at. We're going to talk about who's ready for administrative law right before lunch. How many of the non-lawyers are ready for administrative law? We're going to talk about that, dicamba usage. We'll talk about a few right-to-farm issues that Tony and Jesse did not talk about earlier. And then we're going to talk about the potpourri category that I put together that others told me to talk about when I sent out an email when I did this similar presentation back in October for the Southern Extension economists. Well, it helps if Paul hits the right button. Keep in mind, all of this is how I think this may or may not play out. I have no idea. As I often point out to people, those that can't do teach. I can't practice law, so I teach. So this is where we're at in my life. And also, if I knew how most of these were going to play out, guess where I would not be right now? I would not be here. I would have won the lottery years ago and be a wealthier individual at this point than I am. How many people know what Loper-Bright is? I see a few hands going up. So we're going to start off with it because this one's the one that's probably going to drive potentially some agency decisions as we move into the new administration and how this is going to be interpreted by courts. But for those that do not know, Loper-Bright Enterprises versus Raimondo overturned Chevron deference, a principle that had been used for basically 40 years, and I believe at this point was the most widely cited court opinion in the Supreme Court's history that basically set this idea in place that courts were to defer to agency interpretations when statutes were ambiguous and not substitute their own judgment when the agencies worked well. It was an idea that we should defer to agencies when they had the expertise and courts should step back and away from that. Loper's a 6-2 decision if I counted my votes correctly, because Justice Jackson did not participate in the decision. And this rejects this notion that agencies have this special expertise to resolve when statutes are ambiguous. The courts also have this expertise. There's some law students in the room. You're learning probably as you go through some of this that yes, you are trained to think in ways to how should agencies interpret these decisions. So courts can also get involved in this as well, according to this. It allows the courts to exercise their own expertise in deciding and looking at agency decisions and actions under the Administrative Procedures Act. So a lot of what's coming out of the federal government are going to be these rules and regulations that come out that could be utilized under this rule to be able to do this. Now is where we get into Paul pontificates because Paul doesn't know anything. So this decision was issued in June of this year, as of November 4th, and I've seen this used as a way to think about how is it going to be used in citing. And this is just me going through Westlaw. It's been cited about 284 times since that decision came out. That is not to say all the decisions are negative, and it's not to say all the decisions are positive. I have not gone through and done an analysis of all those yet. That is just the citings that showed up in Westlaw when I did the court search. So the fear for many is that this will lead to more challenges to agencies, that judges are going to go in and utilize their own expertise to sort of overturn agencies' decisions. We've also seen this before, even with Chevron we saw this. We saw agencies step in, or courts step into agency decisions and say, look, this was overreach, this was not a reasonable interpretation, the statute means this, do this. Think about anything that's happened over the past 12 to 16 years with just the way Congress has acted, and then the federal government or the executive branch has had to step in some cases to do that, and some of the yo-yo we have as we go from Republican administrations to Democratic administrations. Jesse's favorite topic, WOTUS, changes with every administration, and we will probably have a change sometime next year to what the new administration wants to have with that. So there's no clear idea as to how far this will go. Within that, we may be seeing it with the citations. Again, I didn't do any deep analysis to figure out, are they actually utilizing this to uphold agency decisions or defer? We have court decisions since then that are deferring to agencies just the same way they would have under Chevron. So who's to know if this is the gloom and doom that was predicted? And I think I get to my next slide. Anyone want to guess what the outlook for this is? I had AI create this image for me. It's just a lawyer throwing money up in the air. It could be a way for lawyers to make money. Who knows at this point? We're still going to have to wait to see how all this changes and plays out over time. One of the areas where we did see the court basically, or a court uphold EPA's interpretation is we're looking at EPA's CAFO permit. This would not be the Maryland permit, but the one that EPA puts out for CAFOs in states where they do not have permitting authority. This has consistently been a problem for EPA over the years. The Ninth Circuit recently denied challenges to EPA's CAFO permit plan. As a part of that plan, EPA put together a panel of experts from stakeholders in the agricultural community to environmental groups to come together and provide insights into what were the best strategies for EPA to think about as they move this permit forward. And then with that, they were going to start studies to look at what those current regulations should look like as they develop those. Does all of this sound like a reasonable plan on EPA's part? Yeah. The environmental groups challenge is saying no, EPA should not have done this first. They should have opened rulemaking and gone through that process first. The Ninth Circuit looked at it and said, no, this is not arbitrary and capricious, a standard that is used by courts when we look at agency decisions. Were they actually arbitrary, or are they based in some rational thought as to how this goes out? They looked and said, no, EPA has the discretion as to when they're going to open their own rulemaking. You can't force the agency to open rulemaking until the agency is ready to do it in a lot of cases, and that's what's being shown here. That under the Clean Water Act, EPA has that ability to go in and do some background research before they go out and start the rulemaking process to begin that rule under the Clean Water Act. So this is an area where we have seen Loper Bright at least utilizing to be upholding the agency's decision on that. As I point out, these groups can still petition the Supreme Court. It's not clear if the court would actually take it up for the next term, not the current term, but the next term. So we'll still have to wait and see how that's going to play out. If y'all have questions, feel free to just shout them out at me, because I'm going to start having some audience participation here in a minute. How many people remember the dicamba decision from earlier this year and had to deal with it? It's my favorite thing when I get to figure out how we get rid of existing stocks of dicamba once the registration's pulled every couple of years. So what happened here is we had a federal district court in Arizona look at basically the EPA process under FIFRA, the the Endangered Species Act, and the Administrative Procedures Act, in issuing a new use. I put new use in quotes because theoretically dicamba has existed for years, but the new use is we have new dicambas that can be sprayed over top, so that is the new use. They've been around since 2020, or this registration's been around since 2020. Let me rephrase that. Basically, with this decision, EPA failed to do any notice and comment on that 2020 registration. There's about to be a thought here. Guess what they also did in 2016 and 2018? They also forgot to do notice and comment rulemaking on the same thing. And each time that the dicamba registration has been revoked, it's been because EPA has failed to do notice and comment rulemaking, the one thing they actually should be good at doing because it's what they're required to do. And I forgot my audience participation question. I'm going to go back a slide. Anybody know why it was challenged in Arizona? No one wants to venture a guess at 11 something in the morning? It's the only state in the Ninth Circuit where this dicamba is actually registered and approved to be used. So it was the only ticket they could get into the Ninth Circuit Court of Appeals, if I remember correctly from talking to some of the agents, or from some of the people involved in both sides of the case. So yeah, that's why that goes out. EPA, for those that were aware of this, issued an existing stock order that allowed for the existing sale of the soybeans. There's soybean varieties that are part of this as well, and other products with dealers that could continue until May 31st of this year, and then June 30th of this year is when everything had to be sold and off the market. And if you have stocks, Good for you. If not, you're probably not getting dicamba this year or next growing season. It's probably going to take another year for EPA to work through this process, especially with the change in administration, to think about how all this is going to work. Now, there's a bigger reason why I bring all this up. Last year, Bayer started suing in federal district court in Missouri, the Eastern District of Missouri, St. Louis, for anyone that was saving the XtendiMax seeds or using other forms of dicamba over the top that were unapproved for over the top application. If if Bayer could figure out you were saving seed, you got hit with the same patent infringement lawsuit we saw with the last round of Roundup Ready technology. While that patent's still existing, Bayer is going to enforce it the same way Monsanto enforced it in the past. But if I keep saying EPA because I'm dealing with EPA at the first part of this. If Bayer could show you are actually utilizing unapproved dicambas over the top of these soybeans, guess what happened to you? You got hit with a bigger lawsuit because now you're violating the registration for the seeds and the limitations for the seeds and the regulations involving the older dicambas. So you were hit with a bigger lawsuit with a bigger fine attached to it to go to the company. Anybody want to venture a guess why Bayer is doing this? What did Bayer get hit with early on when this litigation started, when these products came on the market? Did they get hit with drift damage lawsuits and have a large class action lawsuit that many growers in multiple states got money out of, and it wasn't a small amount of money for some growers, it was a decent amount of money for some growers? I think this is to prevent them from getting another class action lawsuit to show that they're actually trying to enforce the patent strategies against growers so they can show, look, we did everything we could do this time. These guys screwed up. Sue them, not us. They don't want to have to pay that billions of dollars out they had to pay last time. Even though we already talked about right to farm laws, I'm going to talk about two more. One's not really a right to farm case, but I put it in there. Tony already talked about Maryland's case. I'll talk about the Kansas case. The Kansas Supreme Court agreed that a hog farm operator committing trespass, and let me explain to you how he committed trespass to get this whole process started. He needed to run 3 lines to run effluent onto a farm to spread it across his field. He ran the lines in the county right-of-way. He never got the county's approval for it, and he never got any of the neighbors to approve those lines running across the county right-of-way. The county right-of-way exists as a common transportation outlet. Guess what happens when you start putting one hog effluent line down? It's not public transportation anymore. That's benefiting the individual and not the public at that point. He never got any approval for it. In fact, when the county sheriff showed up, as it's highlighted in multiple court opinions involving this guy, he looked at the county sheriff and said, okay, I'll leave now and I'll come back tomorrow and finish this, and that's exactly what he did do at that point. He did that. His neighbors pointed out to him the problems this was creating, and he nicely set everything associated with the irrigation system, applying this to spray on their house. He's like what we like to call a nice guy. At that point, once he did that, he was sued. Multiple courts, all the courts in Kansas have agreed the right to farm law does not apply because the right to farm law in Kansas is written that you have to be following state, federal, and local laws. Guess what trespass is? It's a state law. You can't violate trespass. So because he violated trespass, he doesn't go past go. He doesn't get to collect $200, and he gets to go back to the start and start all over. Also, he got large punitive damages put against him in these cases, which is often sometimes rare. He liked to stack all the nutrients outside his neighbors' houses after they started complaining about this and left them there for days so they could smell everything. He's a winner. He lost in court. Just keep pointing out, he is the Ron Swanson of pig farmers in Kansas because he didn't need a permit. He just did it anyway. But he has now effectively lost, and that kind of highlights when you can lose in right to farm. This one I put in right to farm in Texas, but it's really not a right to farm case. It has similar backgrounds that we'd seen in a lot of right-to-farm cases, but it was much more an environmental case. The Texas Supreme Court reversed the decision, granting an injunction to neighbors to shut down a poultry farm. In that case, the neighbors, the second the poultry farm started operating, started documenting all the issues with the poultry farm, reporting it to the Texas Environmental Quality Board, and they came out and started issuing fines against the farm for their practices, and 2 lower courts agreed that this farm should have a permanent injunction against it. The Texas Supreme Court said, no, we need to go back and relook at this. The injunction's not the right avenue to take with this. So that farm has been reopened. It was a poultry farm growing for pilgrims, if I remember correctly. And it's in a weird area for the state. We're probably going to continue to see right-to-farm decisions and right-to-farm cases come up as we just see people, utilizing that more and more. The next one I want to talk about with my little bit of remaining time is we have this case out of Tennessee called Concerned Citizens of Western Tennessee. For those that have been here before, this is a very similar case that we had in Maryland maybe 5 years ago, 6 years ago. We got a poultry farm that's being established. Farm Credit's financing it. Farm Credit says, look, we'll finance it, but you got to go to USDA, Farm Service Agency, get 2 loan guarantees to do this. They do all that. The growers are growing for Tyson, and it's being financed by Farm Credit of Mid-America. As a part of this, FSA has to do a NEPA review on these loan guarantees. And there are folks in the room from FSA, and they can tell me if this is still the case after this case, but I know things are working to change. This comes even after the Center for Environmental Quality, or the Council for Environmental Quality, the group that handles the National Environmental Protection Act, NEPA.
National Environmental
Policy Act. I get my acronyms confused. It's been a long week. National Environmental Policy Act. That requires agencies to do an environmental review before moving certain projects forward. In 2020, the rules were changed to take out loan guarantees. FSA did not get their regulations changed appropriately, and that has been challenged in federal court, and they are working through that process to remove them. While this case was ongoing, even though it was during the period that CEQ said you didn't have to do this anymore, FSA still had to do it because they had not been removed. Even with the most recent changes, it appears loan guarantees are still not really required to have to go through this review process anymore with the changes that were made this year, or proposed this year by the Biden administration. They challenged it, saying USDA did not do the proper review on this. It should have been a better NEPA review. They also went in and said basically Tyson was the owner of the farm, even though it was 2 individual farmers, and Tyson didn't meet the standards for the loan guarantees that required family farms. Yes, Tony?
2 points on those. These cases, there's a couple across several states that have gone through on FSA challenges to FSA's loan guarantees. And typically they're headed towards the idea where they're going to do, like the Department of Transportation does for NEPA. It'll do a programmatic environmental assessment and make decisions about whether the program is going to impact and types of things that are covered by it. So that'll be a blanket. But also, what's interesting, I found, they do not, if your FSA loan is challenged, the borrower never knows. They don't find out. So that's one of the problems with these lawsuits. If the lawsuit were to end up with the loan being overturned, it's your loan, but you've never been told that your loan was even under challenge.
This is true.
It's difficult.
Yeah, it is difficult. I will say in this case, the borrower was sued, both borrowers were sued, and Farm Credit was sued. They were later kicked out of the lawsuit, but they were sued. The court agreed that the group challenging basically in this and the same case in Maryland who didn't have standing to do this. The redressability issue was the issue in the end. Basically, it takes a while for these cases to progress through the federal court system, and guess what happens as cases progress? These borrowers get a better history of delivering to the bank. The bank's probably less likely to require a loan guarantee if they come back. So why would we make you go back? There's nothing we can do to address this issue. Courts don't really like to do things where they don't have an avenue to give you some sort of finality on what you're challenging. So there's nothing they can do to do this. We saw this in Maryland with the DC Circuit Court of Appeals agreeing with this, And this Tennessee case clearly cited that multiple times through that as a way to move that forward. So hopefully they go a different route to get some of this done like Tony was talking about. And then when I did this for the Southern Extension economist, I asked the people that have my jobs in the South to give me, and Jesse, to give me court decisions to look at. So these were some of them. And this one has just been filed in the District of Columbia in what is their state court, basically. The Environmental Working Group is suing Tyson in DC court, alleging that their green marketing is a violation of DC consumer protection laws. Basically, if you go through the pleadings, the EWG is basically saying Tyson's making all these claims about being carbon neutral. They really can't verify any of these claims. That's misleading to consumers who think they're buying products that are more carbon neutral than what they really are. We're seeing this become a thing more and more across the country. Went to a session last week that was talking about some of this greenwashing litigation, but we've seen this with a lot of companies. It leads to the second point in there. California had their climate disclosure law go into effect, I think, last year. American Farm Bureau Federation and some other ag groups are suing, claiming it violates the Constitution, mainly because the concern is, as we see these greenwashing lawsuits go through, it's going to force producers to do more and more reporting as to what their environmental practices are, what their farming practices are, so these companies can go back and better verify their claims. They're claiming that that requires out-of-state producers to do slightly more paperwork than they had, so we don't, I think it's a Dormant Commerce Clause challenge, but I can't remember. And we'll see how that plays out after the Prop 12 decision as well that came out of California. Electronic identification rule has now been effective for, I believe, a week, because I believe last week was November 5th. So it has now been in effect. It applies to all cattle and bison when they're transported across state lines. They need to have visible and electric ear tags as a part of that. There are, from what I can read, efforts underway to challenge that, but we don't know where that's going to go. Congress did allocate money to help producers buy those ear tags, so if you need that, I think the Maryland Department of Ag sent out an announcement last week, 2 weeks ago, saying they had electronic ear tags available to producers, so if you need that, that's out there. For those that are unaware, Congress passed a law a few years ago and passed it over a presidential veto to file your beneficial ownership interest. For most small businesses in the U.S. are going to have to do this. This has to be done through the Department of Treasury, through CINFIN reporting to help prevent financial crimes. That's got to be done by the first of the year. It's a pretty simple process for most folks to go through, but you need to get it done. If you had that, the only people exempt from it currently are members of the National Small Business Association as of March 1 of this year, because there was a court decision that involved them that said it was unconstitutional, so we will wait to see how all that plays out for folks to see what's going to happen there. And then the case Jesse sent me, Conley versus the United States. Here we have a small family-held company, and as a part of it, they had an agreement built up and put out life insurance policies on each of the two owners. There were two brothers' lives. These company-held life insurance policies were there basically when one of the brothers passed away. They would turn around and utilize the life insurance policy to buy out the estate of that person's share, so it went to the existing company or the remaining shareholder on that. The Supreme Court ruled in a 9-0 decision that yes, you have to include the value of that life insurance policy in your individual estate. So even though it was a company-held policy, it needs to be valued as a part of the individual's life estate, or the individual estate as well, for estate tax purposes. So that's going to have a lot of implications as we look at how do we set up some transition plans for some of these farms. The final thing is there are new collective bargaining rules that have gone into effect for H-2A workers. Those have been challenged, and a federal judge has blocked them in 17 states. I have 17 states on the next slide. I hope somebody can count to make sure I grabbed all 17. But if you're in Virginia in this area, this rule is currently not in effect in Virginia, but it's in effect in Maryland, Delaware, West Virginia, and multiple other states in the region. So the wrap up, and then I got about 10 minutes for questions. So we're probably going to see some impacts from Loper Bright. Who knows what that's going to be in the future? We just don't know at this point. We're not going to have dicamba next year for the next growing season, but that will probably change as EPA gets the next registration put together, hopefully with notice and comment this time. And yeah, don't misspray the older stuff, because if bear catches you, you're probably going to pay a lot of money. Good luck with that. And then right to farm decisions are still out there. They're still haunting us from time to time in various situations. And then I just put everything on a big, long last slide. Green marketing lawsuits are here to stay for a while. I think we're going to see, as companies continue to make these green claims, more and more people are going to start looking at them and challenging those to make sure they're actually being verified. We've seen this with Delta, with some of their climate impact chain things they've made. They've been sued. Other companies are being sued beyond just Tyson looking at this. So we're going to continue to see this, and it's potentially going to force a lot of this stuff down the supply chain for folks to start verifying. If you got cattle that are going across state lines, get your EID tags, get your beneficial interest reported to Department of Treasury. We got to look at how you handle life estate now when it's a company's insurance policy. And H2A in a few states can now collectively bargain. What questions do y'all have? Put my contact slide up. Yes, Karen.
Could you explain what this beneficial interest is about, what that's about?
The thing I didn't want to have to answer, because I don't have all the notes in front of me. So basically, if you own any business that required you to file paperwork with the state to get it started, so LLCs, corporations, anything but a general partnership, if I can remember correctly, you've got to file paperwork highlighting who all the owners are in that business and how that membership is set up.
So not sole proprietors?
Not sole proprietors. Only businesses that file paperwork with the state to establish them.
Or is that nonprofits?
I think they would have to file it, but I don't have the chart in front of me.
I think they're exempt.
Okay, they're exempt. This is what happens when I don't have like the chart that Christine put together in front of me. Who else has questions?
Paul over here.
Oh, yes, ma'am.
I just wanted to comment on the BOI requirements. It's any and all LLCs, limited liability companies, corporations that are, regardless of the state in which you have filed, but if you're an LLC, organized as an LLC or a corporation, you must register if your gross receipts are under $5 million. Certain nonprofits are exempt, 501c3s. If you are a business, like a membership organization, an association of a professional group, you should check on that. But everyone must file, and what you need to have in your possession when you file this document or file this registration is a photo identification. Driver's license is preferred, has to be current, and all owners have to be part of this registration. So if you just own a rental property that you put in an LLC because it's a rental property and you're told, well, you have less risk if you have a rental property LLC, that every one of those LLCs must be separately registered. And I'm speaking in my capacity as a tax preparer. So that's why I'm familiar with this, because I am doing this, a lot of this. So you have to be able to upload your identification. And the penalty is still $500 a day if you don't file this registration by January 1 of 2025, if you were in existence before January 1 of 2024. That's the deadline. And yes, I think it's unconstitutional too, but I wasn't a member prior to March 1 of that organization. Thank you.
I was going to say, and the group that's enforcing it is known to enforce when people violate the laws. So you will end up with a $500 fine per day that you are out of compliance. Now I see a question over here.
Do you know if they are
They are not. As long as you're not currently registered with the state, you should be good, is my understanding. Or it's gone inactive, I guess is the best way to put that. Yeah. What else?
All the local decision, do you think that will have any effect on state regulations, state, laws?
I don't think it'll have minor impacts on states because state laws and state agency decisions are still going to be challenged under whatever the state process is. So in Maryland, we're still probably going to have some version of Chevron. Other states still are as well. It's just currently on the federal court side. As I point out to all the law students who work for me, I'm glad those that are taking administrative law now are learning it the correct way, unlike me who learned it the incorrect way and have to relearn everything I knew about administrative law. What else? Y'all still got 8 minutes to ask me questions. I timed this out to give you time. I'll have to start doing songs and dance. Oh God, Peggy's got one.
Do you see anything new on the horizon coming here from Maryland in the next year or so? Any new legal issue that you're starting to ponder?
I think the biggest one has just been greenwashing and thinking about how does that play out in some of the claims being made by companies in the state. And for me, that's been the biggest one.
Do you see anything as far as immigration employees on farms becoming litigated?
Can you say that again?
Non-American immigrants working on farms. Do you see anything huge coming up in there? I mean, they're writing the laws now.
Yeah, so you mean like H-2A or?
Yes.
I don't see any major things coming up with that. I see it much more just potentially making sure everybody's in compliance with the law to make sure they're coming over here the correct way so we don't end up with problems down the road, depending on how the next administration handles immigration issues. It's just me guessing. What else? If not, I can quit. And I can turn it over to our pre-lunch address. Okay, thank you guys.
Hello, everyone. So we're going to catch up on time because I'm standing between all of us and lunch, so I'm just going to talk for a minute. I'm Deb Eisenberg. I'm Vice Dean and a professor and director of the Dispute Resolution Program at University of Maryland Francis King Carey School of Law, and I'm also on the advisory committee for ALEI. So I work with Megan Todd and Kimberly Fullerton and collaborate with the other leaders at the other schools to really bring this fabulous program. So I grew up in Southern Maryland, so farms are very important to me. Farms were my neighbors growing up, mostly tobacco farms in those days. And now I live among the farms in Western Howard County. And as I don't have to tell the folks in this room that farmers are so important to the fabric of Maryland. Farm agriculture is a bedrock of our community. It is the fabric of our landscape. Farmers produce the foods that nourish us, and farmers are stewards of the land. When I was in college, I worked for State Senator Bernie Fowler, who represented Calvert County in Southern Maryland, and he was a big proponent of open space laws. So he valued farmers. He also was a big proponent of the Chesapeake Bay, and he was an example, like ALEI is, of how do you bring those together, right? How do you bring the environment and agriculture together so that it is producing wellness for the entire state. And that is what ALEI does. You know, all of you know that farmers have to navigate a complex array of laws, from environmental laws to contract laws to leases to estates and trusts to so many other things. And that is why ALEI exists. The working group at ALEI is fantastic, helping farmers across the state really understand this complex thicket of laws and do the right thing, which is what farmers really want to do. And at Maryland Carey Law, we are really committed to educating a pipeline of lawyers who will go out and practice agriculture law in various ways, whether representing
farmers, being a solo practitioner in a small town and helping the farmer down the street, through working with government agencies and helping to implement laws in a way that is beneficial for farmers. How many Maryland Carry Law folks are in the room, either alums, current students, or staff, right? So every year I come to this conference, I like to see that number increase. I think last year we had like maybe 2 or 3 in the audience. This is a better showing, and so we are committed to increasing that every year. So we really value this collaboration. We really value this empower relationship between the 3 campuses. I think it's very important in a small state like Maryland to have this collaboration across different universities. And with that, I'm going to stop talking. I've learned so much. I've learned what dicamba is. I've learned so many different things this morning. So just soaking it all in, really learning as all of us in the room are. And so let's have some lunch and get an extra little bit of a break. So thank you.